Justice isn't always black and white. In today's gripping courtroom case, emotions run high as a judge delivers a powerful sentence, confronting denial, accountability, and the consequences of one's actions. Watch every tense moment unfold as real courtroom drama reveals how a single decision can change a life forever.
Is Braden Sandell, 2300418SM.
Andrea McCray appearing on behalf of the people.
Patrick O'Keefe on behalf of Mr. Sandell.
And you, sir, you're Braden Sandell.
Yes, ma'am.
Okay, keep your voice up so we can record you.
Yes, ma'am.
Thank you. Today is the date for sentencing. We had a trial in this matter where the defendant was found guilty. We have a pre-sentence report with recommendations. Mr. O'Keefe, you've been able to go over that with the client?
Yes, I have, Your Honor.
Additions, deletions, corrections to the factual content?
We have none, Your Honor.
Ms. McCray, you did enter your appearance today. Do the people have anything for sentencing?
No, I mean, I'll just note for the record that victim in this matter, Ms. Boss, did not want to be here today. She thought there was going to be, her words were, a lot of tension in the courtroom. But I've had good contact with her. She was happy with the outcome. Awesome.
Mr. O'Keefe.
Your Honor, we filed a petition to defer the conviction under MCL 769.4A. It's my understanding that the people are objecting to that. So I would just ask that the court grant that petition.
I don't think I have authority to over an objection. I think the statute specifically gives the discretion to the prosecution.
And that was my understanding, Your Honor, of the statute. And to be clear, I am objecting.
The consent of the accused and of the prosecuting attorney in consultation with the victim. So it requires consent from the prosecutor.
I see. Okay, Your Honor. Well, given that they're objecting, I think the court's correct. It would not be able to defer the conviction under that. So I'll withdraw the petition.
Sure.
I suppose I'll keep the petition on the table, but given that they're objecting, I'm not going to ask the court grant the petition. Aside from this, Your Honor, the court heard all the testimony in this matter. I know the court has had a chance to review the pre-sentence report. I think the pre-sentence report is accurate. I think the recommendations made in the pre-sentence report are appropriate. I would simply ask that the court enter an order adopting all the recommendations in the report. Thank you, Your Honor.
Mr. Sandell, what would you like to say to do for our sentencing?
Mr. Sandell is very nervous and he's indicated he does not wish to address the court at sentencing today. Thank you.
Okay. Brings to mind, the pre-sentence questionnaire, wherein he could provide his circumstances of this. He could have said, I had a trial, I maintain my innocence, I don't want to talk about it. But this is what he writes instead. I dated a very shitty person who lied her way into getting me in trouble. That is what Mr. Sandell thought was the appropriate response to a court pre-sentence questionnaire after a conviction. I did hear the testimony and evidence in this case and observe the demeanor of the defendant during the trial, as well as observing his choice in the questionnaire. It's the reason why they tell you sometimes remaining silent is better, because this is offensive. This is victim blaming. I don't care for it. I think that you are a very arrogant young man, and unless you begin to have some, introspection about your own role in your behavior, nothing's going to change. Mr. O'Keefe, has your client started a BIP program already, or he would be starting anew at this point?
The Batter's Intervention
Yeah.
Program, I don't believe he started that yet.
Okay.
Is that correct?
It just affects the length of the probation because it can take a whole year to complete. The assault that was described during the trial was pretty significant, continuing assault. Sentence of the court will include probation and jail. Probation term will be ordered to be 12 months. As I said, it can take you 12 months to finish the class, and therefore I have to give you 12 months probation to give you enough time to complete that class. It's really 6 to 12 months, but it sort of depends on your assessment and your participation in the class. So you can choose to go to the class and insist that you have no wrongdoing and you're not there to learn anything, and you'll probably be there longer. Or you could choose to go in and decide that you wouldn't be in court if you didn't have something to learn and try to learn something from the class and complete it. During probation, meet with your probation officer as directed. Do not leave the state without permission. Do not commit any crimes. You're not to have contact with Sydney Boss without permission from the court. You're not to engage in assaultive or threatening behaviors. You're not to use alcohol, marijuana, or controlled substances without a prescription. You are to submit to random testing to prove that you're remaining sober under court order, and you're not to attend bars or nightclubs during the probationary term. Does your employment take you into bars or nightclubs? Okay. It's not very specific. It just says union labor, so it doesn't really tell me exactly what you do.
He builds bridges,
Okay.
construction.
I do remember that from the trial. Yep. You are to complete the domestic violence batterers intervention program. Further, I've ordered if you test positive for some substances, you'll complete a substance abuse assessment and follow those recommendations. You're to maintain employment. You're not to purchase or possess firearms during probation. The probation oversight fees are $30 per month for 12 months. That's $360. There's a $60 state minimum cost. There's a $75 crime victim rights fee. There's a $250 fine for a total of $735. You will begin your probation by serving 6 days in jail with credit for the 2 that you've already served. If you'd like to appeal my sentence and you need a public defender to assist with your appeal, you need to make your application within 14 days. Questions about your sentence, sir? Mr. O'Keefe?
Would the court give him the opportunity to report on Friday night? Which, given that I expect he's probably scheduled to work in these next couple of days. I don't know what his work schedule is off top. We haven't discussed that, but I just want to make sure that he's able to keep his job and make arrangements to take the time off to serve the time.
Okay, beginning Friday, June 30th at 7 p.m. Just remember that I don't delay sentence very often, so since you got a delayed sentence once, I won't delay it again. Don't violate your probation.
Sure.
Thank you. Versus Jermaine Newell, 2202651FY.
Andrea McCray appearing on behalf of the people.
And you are Jermaine Newell.
Yes.
Today is the date for defendant's motion for early discharge. So just to sort of recap, Mr. Newell was allowed to plead to operating intoxicated second offense and possession of a firearm while intoxicated back in November. In January, he was given 9 months of probation. So would that take us out to like October-ish would be your end date? Does that sound right?
October 9th.
Okay, October-ish. I do have an email. Oh yeah, here, they wrote the end date, I think, on here maybe. No, that's not the end date. Mr. Hannah did send me an email, so I'll read that for the benefit of both prosecution and defense. It says, Mr. Newell completed treatment at Cristo Rey, is continuing treatment on his own. He attends 12-step meetings most days and has all of his fines and costs paid. He has been a model probationer that has completed all of his required programming. He has had no violations since his sentence January 9th. Ms. McCray, on your objection.
Yes, thank you, Your Honor. So while I'm very happy to hear that he's doing so well, that really is all very good to hear all of that. I know that trying to maintain sobriety is a daily challenge. And so I certainly commend him for that. So I hope that maybe he won't take personal offense to my objection. But this is a second OWI. It was done in November, so this was done prior to me as being the prosecutor. But I think, well, I won't go into that. But there was also a gun in the car. So for those reasons, Judge, I'm going to have to object on this one. Though I think he's probably the best case of people that are successful for the OWIs that have come before us. You know, just because there was a gun in the car and it was second, I'm going to have to maintain my objection.
Okay. I just want to note for the record, the prior was December of 2017. So it hasn't been 10 years since your prior. It has been, at the time of this event, only like 5 years. So, Mr. Newell, I guess tell me why I should feel like it's safe to let you off probation early.
Okay, first mostly because like the last time when I was here, you told me about the whole, it's mostly grief and the death of my family. That's why I was doing it. Like my wife passed in 2016, so 17, you know, we were doing this and doing that. And I had a couple of drinks and then I drove and I shouldn't have. And then the second one, like I said, like I lost my mom's sister and my brother. My brother was killed in October of 2020. And then my mother died in 2019 in November. My sister died in June of 2000. So there was a lot of death. But when you told me the last time when I was here, you was mostly like, it's always be death. So you got to find out a different way to do it. So that's why I'm still attending Crystal Ray, trying to, we were doing the grief thing. So that's why we were doing that. And I accomplished that as far as saying what I needed to do. And I figured out in my own mind what I needed to do. So that's why I take the one step at a time, like say 24 hours of sobriety. As far as the gun charge, was like I guess me growing up, I always had a gun, you know what I'm saying? My license to carry a gun, you know what I'm saying? Like for protection wise on, you know, cases or whatever, because I just got robbed not too long ago or whatever the case.
Did they take your concealed pistol license because you got an OWI?
Yes.
Yeah, I thought so. They won't let you carry when you get these drunk driving charges. I think at the first one, they take it for like a year. And then now that you have a second one, I don't know. Are they ever going to get that back to you?
Yeah, I'm not worried about it anymore.
It's a little concerning to me that you said you grew up always carrying a gun. Because
No,
I feel like,
not like carrying guns. Like I was born and raised in Alabama, so
Yeah.
we did a hunt. And
I just feel like that's the problem today. I guess I'm a little sensitive to it because like 2 weeks ago, I was hearing a case where a 13-year-old, a 17-year-old, an 18-year-old all showed up with a gun. Why does everyone got to have a gun?
yeah, no.
And you know how that turned out? Everyone started shooting.
It was like, oh, my bad, I'm sorry.
Oh, no, go ahead.
Was like I never had like I haven't used or I never thought of using a gun as far as like trying to kill somebody or rob somebody. You know, I always worked for my own and took care of my own stuff. You know, I'll be 50 next year, so like not 12. You know what I'm saying? So I don't consider it to be like a weapon of defense or whatever. It's just more along the line of.
You had it when you were drunk and you can't do that. You
Yeah,
do
well,
that.
I had it. I thought it was in the trunk because I wasn't drunk when I went to the, you know, until we went to the bar, and then that's why I had it. It was on the, it was
Yeah.
just laying on the back seat or whatever. That's why I told her. Yeah, then I thought I put it in the trunk,
Yeah,
but
that's super unsafe too, you know, because people keep stealing guns. So, yeah, they were stealing, they were just like broke your window, took the gun. Yeah. Okay. Well, I understand the prosecution's objection, but Mr. Newell, you have a plan in place if you're feeling like, one, if somebody passes and you're feeling that way again, or two, if you're feeling like drinking, you have a plan?
yes, I don't even drink anymore. I got my 8 months now.
Do you have a sponsor?
Yes, I have a sponsor, John C. Wrote a letter.
Okay. Are your sponsor wrote a letter for you?
Yeah,
Can I see it? Well,
Yeah,
can I see it for the court?
Sure.
and then
Just interested.
If you took the time to write it, we should look at it.
Also, Chris Wright,
Your counselor, you mean?
yeah, my counsel.
The record, I'm in possession of 3 letters written on behalf of Mr. Newell, which speak very kindly of him and his progress.
I just had a uncle that passed. That was like my father figured out south, whatever. A probation officer let me go, and then when I was down there, you know, I didn't think about the whole drinking thing. You know what I'm saying? More along the line of like, just wanted to be there for him. And then my son, he just graduated from college from Kansas State for aerospace engineering. And I wasn't able to attend it, so it was kind of like hard, you know, because I couldn't leave out the state.
Yeah, I mean, whether I let you off probation today or I let you off in November, there comes a time where you're no longer accountable to me and you have to make choices because you're accountable to the community in a way, right? If you get a third one, you're talking a felony charge, you're talking potential prison, you're talking lives at risk. So it's important that you are able to recognize if you're starting to say relapse occurs in your mind before it occurs physically, if you're starting to relapse in your mind.
Also, through my job, I got I'm doing a counseling process through my job too, you know what I'm saying? Because, you know, like, we're not supposed to drink there, you know what I'm saying? I've got to build plans for it, so like, they don't want us, like, we can't be drinking, you know, like that.
There's not a lot of jobs where I think you can be drinking at the
like,
job.
right, random drugs, you know what I'm saying? Like, they don't accept that either, so. My thing is I went through there too, so I can go through MedLife and stuff together, whatever.
Well, Mr. Newell, I would say you're an exceptional case. It would not be often that I would think that you could complete probation this early on a OWI second offense. But in light of your completely no violations, the fact that you started doing all of your probation right off the get, and the impressive support letters you provided, which include you having a sponsor that you work with, I am granting your motion for early discharge. You're not officially off probation, so you get the signed discharge paper. So keep in mind that might be a few days that you're still on probation before you receive that. Don't do anything bad while you're waiting for your paperwork. That would be silly. I want to return these to you so you can keep them for yourself. So you can walk up here and take them.
Do I still go to my class and attend everything that?
You keep doing everything until you're discharged. Okay. And then after that, you keep doing everything you think you need to do to stay sober.
Oh, yeah, no problem.
You don't have to, like, you know, that's good for you.
Take care.
All right.
Thank you.
Bye, Mr. Newell.
Congrats on all your work.
In this courtroom session, justice takes two different paths. One defendant faces probation and jail after a domestic violence conviction, while another earns early release through sobriety, accountability, and rehabilitation. Their stories reveal how courts balance punishment, responsibility, and second chances in the pursuit of justice.